Okay, I'd like to call to order the Planning and Zoning Commission meeting as of July 12th, 2022. First order is to approve the June 14th Planning Commission minutes. Do I have a motion to approve?
So moved.
I'll second.
Okay, next we have staff report.
Hold on just one moment. All in favor, say aye.
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 Any opposed?
All right.
Now we're at staff report,
Staff
sorry.
report, yes.
Can you, is my mic on? Yeah, there we go. We're about the same as we were last month on single-family residential permits. I still think we're at 53. And still no new commercial construction permits, although we did receive a tenant finish for the old Price Chopper building on a portion of it. So they're going to start demolition for a tenant in the middle of that building. And I understand from the contractor, not the owner, the contractor, that they will be coming forward with a site plan approval for a new facade improvements, including putting 7 units on the east side of the building facing 169. So there'll be 7 doors. Haven't seen any plans, any iterations of it, so I don't know what it's going to look like, nor do I know who the tenants are for sure in anything. So, but that arrived today. Diamond Creek at 6th and Manzanola is 99% done, 98% probably. They've got some more work to do. They are preparing to finalize the bonds, both maintenance and performance on that. That should start houses in that subdivision rolling pretty soon as well. The medical marijuana facility is still under construction. They're moving forward. It's such a huge facility that they're hoping, they were hoping for July 31. I don't think that's even a possibility at this point. They've only got half the power in right now because of the problems with Evergy getting parts to something, I don't know, sectionalizer or something. So they're trying to figure that out and when that's going to be able to get them open. Shamrock is now a full certificate of occupancy, and it has been sold, and they're waiting on a few closing items so that they can then, the new owner will stock it and start. An attic storage, the indoor storage complex at the south end of town is under construction. If you drive up 169 on the way in on your left, you'll see the construction. I think that's all. If there are any questions, I can answer those.
If not, thank you, Jack. Move on to item number 4, the conditional use permit, telecommunications tower at 904 Northeast 180th Street. We're continuing this from our 6/14/22 meeting for the purpose of voting on the individual findings of fact. And before we start that, I would like for our attorney, John Frederick, to kind of go over this process with us.
My understanding is that the last meeting, there was a recusal, and so we ended up with 3 and 3, and then we had a 3-3 vote. And in doing that, it really doesn't go to the Board of Aldermen with specific recommendations, but within our ordinances, there are also requirements of specific findings. So as the Board of Aldermen, to whom you are going to send this, in essence, a nay vote to the Board of Aldermen as a recommendation, because the public hearing is in this forum, there needs to be specifically findings of what our ordinances require of findings. We haven't done that, so we would ask you to go back and vote on those specific items so that we can have a complete record to present to the Board of Aldermen. Okay.
And my understanding is we could ask questions at this point. We normally wouldn't, but
If you're talking about at the audience or something, normally you would not. The public hearing has been closed. Having said that, it's a public forum and a public body. If somebody wants to say something now, you can give whatever weight you want to it or not give weight to it.
where I'm asking for questions is if there is somebody here from this that wants to put up the telecommunications towers, if we've had specific questions as a member of the committee to ask them directly on a finding of fact.
I don't see that.
And if there's nobody here from there, then that'll probably take care of any questions we, the committee, would have.
I do
Mr.
have,
Beggs is-
yeah, I was gonna say, Mr.
Mr.
Beggs filled out
is
a
here
card.
himself. But I don't think the conditional use applicant themselves are here or are going to be here. They had understood that it had to go to the board
Okay,
based upon whatever happened tonight.
okay.
I do have a question. I'm here on behalf of my daughter, son. She owns a property next to Fix. And she's in Detroit right now. And, you know, we are looking at purchasing that property from her. And I was wondering, you know, what some of those, I guess that means, what some of those findings were, because I don't want to have property knowing this.
Well,
right next
that-
to
Yeah, first, I
the
think
town.
if I could, I would clarify, there have been no findings. There are no findings. That's what they're going to vote on now.
There was a general up and down approval and non-approval, and that goes by 3-3. Now we're gonna say, okay, in addition to that, we're finding these facts that are applying to the CUP and the whole package of the Board of Aldermen.
Okay, so it's now no more votes. is what you're saying?
They will vote individually on the findings,
Okay,
but the overall vote's already taken place as to whether or not there'll be a recommendation to approve. The vote was 3-3, so there's no affirmative vote to approve.
okay, because I've talked to a lot of the neighbors in the area that were express concern.
Okay, I,
The ultimate decisions for the Board of Aldermen.
Okay, so
This
we
is a
should
rec-
write the Board of
this is-
Aldermen.
This body holds the hearings and makes a recommendation after hearing evidence, so forth, to the Board of Aldermen. But the ultimate decision is the Board of Aldermen.
where I was asking if questions we asked was as with the committee members as we go through the findings of fact, because the other portion had been closed. So at this point, we will go through the findings and facts. We'll start with findings number 1. I guess I need a motion to discuss finding of facts.
Well, actually,
Oh.
I need to recuse myself
Yes, you
again,
do.
and so I will be abstaining from all votes regarding this topic. Thank you.
Yes. Then I need a motion and a second to discuss the finding of facts.
I'll make that motion.
Second.
Okay, so we'll move on to the first finding of facts. Jack, do I read these?
Yeah, or you can identify it. You have before you the memo that lays out what the specific code requirements are. You also have from the previous meeting, the proposed draft findings. So ultimately, if you want to walk through the proposed findings, that's fine. Or if you want to walk through the ordinance and come up with your own findings through discussion, that's your prerogative.
I think at this point, I'll read, just that pursuant to the provisions of section 400.570 concerning the minimum requirements for the issuance of a special use permit and based on the testimony and evidence presented in a public hearing of the Planning and Zoning Commission held on June 14th, 2022, the Planning Commission of the City of Smithville hereby gives the following findings of facts and conclusions of law. We'll go through the findings of facts now. Number 1, the proposed special use complies with all applicable provisions of the zoning regulation, including intensity of use regulations, yard regulations, and use regulations.
And
If you agree.
procedurally, if there's no discussion on it, then you just call it, it's the way it's worded is it's an affirmative that it does comply. So if you vote yes, you're saying it does comply. If you vote no, it means it doesn't comply. Does that make sense?
Yes.
Okay.
There's no discussion. I'll ask the clerk to call roll.
Billy? Deb? Melissa?
Yes.
Mayor Boley?
Yes.
And Dennis?
Yes.
5-0.
The next item, it is found that the proposed special use at the specified location will contribute to and promote the welfare and convenience of the public, and that it will be consistent with the nature of the neighborhood and will provide a service enhancement to spotty cellular service. Any discussion? Seeing none, clerk call roll.
Deb,
Yes.
Dennis,
Yes.
Mayor Boley,
Yes.
Melissa,
No.
Billy,
No.
3-2.
Number 3, the proposed conditional use will not cause substantial injury to the value of other property in the neighborhood in which it is located. The monopole has limited visual impact to any adjacent property. There isn't any discussion. I'll have clerk call roll.
I had a question for Jack.
Okay.
So Jack, on one of the things that was mentioned last time was the shared use driveway. Is this where anything would be changed in this one?
3?
Yeah.
No, I would say the driveway stuff would be. Yeah,
7.
7, sorry.
What about appearance of the pole? Kind of in some places they've,
Yeah, I think this would be the visual appearance,
yeah.
most likely. It could apply in several of them, but
Yeah, because all they mention is the trees. I know they make the poles to look more like trees, but that's something we'd want to add in here. If they did construct a pole, it would have to be one that is not just a regular metal pole.
I didn't know that was an option.
Yeah, a lot of the cell companies have started doing that where they look like trees.
They're all over the place in Florida. They look like exactly like.
That's right, yeah,
Yeah,
so
trees. and
Florida and
everything.
Colorado and
Yeah, I love,
to clarify from a procedural standpoint, if that's the case, you'll want to make sure you amend that to
Number
word
3.
that way.
I would feel better about it if we did amend it to do that, so that it would have some, it would not be a visual eyesore to the neighbors. It would have an aesthetic, a nicer aesthetic. And it would actually set a trend, I think, for the city going forward with other communication towers.
So what I would need is, you want to make the amendment? And they'll need an amendment and a
What's-
second,
Okay, what do I do to make this amendment then?
that the pole will be
Okay,
aesthetic in looks and look like a tree. They'll have to make it look like a tree. I
All
did
right.
see pictures of those when I did some research,
Yeah.
so I was,
I make a motion that the pole look like a tree.
need a second. for the
second,
Amendment. Clerk call the roll.
Melissa,
Aye.
Mayor Boley,
yes.
Dennis,
Yes.
Deb,
Yes.
Okay, now we.
Billy,
Yes.
5-0.
Okay, now we move back originally with the amendment now, that the proposed conditional use will not cause substantial injury to the value of other property in the neighborhood in which it is located. The monopole has limited visual impact to any adjacent property and will look like a tree. Clerk, will you call roll?
Billy,
Yes.
Deb, Melissa,
No.
Mayor Boley,
Yes.
Dennis,
Yes.
4-1.
Okay, we'll move on to number 4. The location and size of the conditional use will not dominate the immediate neighborhood to prevent development. The existing mature trees surrounding the property, as well as the distance from any property boundary limit, will limit impact on the adjacent property. Any discussion? If not, clerk call roll.
Dennis,
Yes.
Mayor Boley,
Yes.
Melissa,
No.
Deb,
Yes.
Billy,
Yes.
4-1.
Number 5, there is sufficient parking for the anticipated maintenance vehicles. Is there any discussion?
Yeah, we're back on that shared driveway thing again. It seems to me that the company wanting to put this in bears some cooperation and responsibility to help service that whole area. I mean, if it's shared, they're using somebody else's shared driveway to access this thing. It seems like they should have some skin in the game, so to speak.
In this, they're actually talking about the X area with actually parking at, not being. at.
Yeah.
Okay, the
Yeah, I
parking,
think
would-
that'd
it would
still be
not
number
be on that
7.
property then?
It'd be-
I
It'd
think
be
you're,
on the
you're
property.
talking about item 7.
Okay,
That's Billy's.
They're talking about parking just at the tower to make sure there's actually adequate room there.
so where the tower is, that would be where their parking is.
Yes.
Okay,
Yeah.
got it.
Off on that, Jack, isn't it like 150 feet? What's the standoff on it? Is it 100 and some feet or something?
Oh, the setback?
Yeah.
Yeah,
It looks like the,
I think it's 198, the
So
closest
There'd
property
be, there'd
line.
be adequate, there'd be plenty of parking in that area.
Yeah.
looks like 50 by 50 is the, or 50 by.
Height is
50 by
fenced
60.
at 50 by 50. The setback is 198 feet. Sorry, I misunderstood your question.
No, that was my question, but yes, the parking is, I see what you're saying.
Any more comments, questions? Clerk call roll.
Mayor Boley,
Yes.
Melissa,
Yes.
Dennis,
Yes.
Billy,
Yes.
and Deb.
Yes,
5-0.
Number 6, no utility, drainage, or other such facilities are needed as a result of the application.
What is the power requirements come to the tower?
I don't think the application specifically calls for it, but our other ordinances require them to install it, and it has to be underground.
do this, is that going to impact like number 7, that shared driveway again?
Theoretically, it could,
It-
just like cable being run up there or whatever else.
There's also existing transformers on the hill there, and they probably have enough on the primary service tap off of that. So I don't see them trenching all the way down that driveway. I'd see them coming from one of the local transformers there, because I'm sure it's just gonna be a single phase 200 amp. So they may just tap off an existing transformer.
Yeah.
I don't see that being a challenge.
Any other discussion? Seeing none, clerk call roll.
Dennis,
Yes.
Yes,
Billy,
Yes.
Melissa,
Yes.
Mayor Boley,
Yes.
5-0.
Number 7, adequate access roads and entrances are provided. I think this is the one we're probably going to want to
yeah.
have an amendment of some sort on, I'm thinking with the questions that's already been asked.
I just think they bear some responsibility to the maintenance of it, since they're going to be using it for commercial purposes.
Surely during the construction phase. I mean, they said after that they'd be out there maybe monthly, one vehicle, but when they're hauling in
Yeah,
cranes and whatever they need to construct this tree, there's going to be a lot of impact on that driveway.
I think one of the things too, we need to look at is at the end of the driveway in that culvert,
Mhm.
because I think that's only like 11 feet wide.
Yeah.
So they start pulling trailers and cranes in there, they're gonna definitely jack up definitely the entrance of the road, if not.
yeah.
More
they
than
need-
that.
They need to be completely responsible for anything and everything with that private drive during
So-
construction phase. I mean, that's my feeling on it, because I don't think the residents should have to bear any aggravation from that at all.
So how do we,
How would you
Word the
word that
amendment.
one?
can we make,
So Jack, one thing I noticed when I went and drove up there is it's one of the entrances that's not concrete. Which now if it
That's
was built
the
today, it'd be
approach.
concrete, right? So if we had them improve the approach to replace that culvert and make it a concrete apron, that'd get it up to current spec, right?
That would get the approach up to current spec. We have no specifications
Yeah.
on driveways
Yeah.
themselves. They can.
And
be
then have them
dirt.
replace the gravel when they, because I mean, after it's built, I mean, it's no different than somebody sold one of the houses and they had 4 teenagers driving in and out of there every day too. It's,
How much How often are they required to mow this setback area or?
No,
Or-
I think that would be the owner of Mr. Beggs' property.
Okay, so they
Yeah.
can still hay it, do whatever they want.
Yeah,
It's just
yeah,
has to be it. They just can't have any structures in that area.
Well, it's purely to the property line. So, yeah, there's structures in that distance, Mr. Beggs' house, et cetera. There's
What's-
usually properties. It's just not somebody else's property.
Okay.
Or buildings, I'm sorry.
I think we need to put a motion forward to saying that to have the culvert put in and have it widened. And then what's your standard going up the road, Jack? Is that 20 feet from the blacktop on the approach?
It's from the edge of pavement to the right-of-way line, whatever that distance is.
Do we know what that distance is here?
It depends on where the road sits. So it's anywhere from 11 to 15 feet.
If you're gonna do an
Back.
amendment, just say to the right of way line or to meet current, you know,
Driveway, what you're.
I'd like the approach be raised up to the current standards and up to the amendment line. Is that what you
Right
said?
away.
Right away line.
Driveway approach to current city standards. Is that what you? I heard you
Yes.
say?
And then I think we should have something in there regarding the gravel or something after the construction done that is cleaned up and put back.
Driveway approach to current city standard and restore.
Yeah,
Let me ask just one question. As far as that's going to be improved, possibly going to create drainage issues down on the front side of the property. Can you consider that also?
Yeah.
I say add drainage to the mix, make sure the drainage is appropriate.
That's all part of the approach
Okay,
design.
part of the approach.
There's a
design,
culvert
okay.
already there. They'll have to reinstall the culvert. And the approach must be concrete, 6 inches thick instead of gravel like it is now. The
But the-
width,
The tower itself isn't going to create any drainage issue. It's
No.
just, so once the approach is put in correctly.
Okay.
that'll be inspected when it's done.
We aren't having public comment. I know. Well, okay. Fine.
A 40-foot path from the edge of the asphalt back toward the street. 11 foot was required to install 15 years ago.
Okay, thank you.
so if he's talking that an approach was in fact installed that distance or whatever, then it may very well already be in compliance, but that would be subject to an inspection by building inspectors.
And they will do that at that point in time, correct?
Assuming this moves forward.
Okay. I think I'd like to add into that amendment about the approach to make sure that the driveway is put back into the state it was before any construction work was done.
Restore driveway.
Yes, restore the driveway.
So the discussion has been driveway approach to city standards and restore the rest of the driveway to current conditions.
Yes.
That's the,
I'd like to see the city standards on that then. If we're saying we're going to put it back to city standards, what is the city standards on it?
city standards are 6 inches of concrete from the pavement to the right-of-way line.
What's the width?
The width is dependent upon the applicant's request. It can be well, we don't have a minimum. So it could be 8 foot, whatever, to get a vehicle across, up to 30. We have a maximum, but no minimum. Does that make sense?
Yeah, that's my point. I don't want to see a standard driveway coming in. If they're going to be pulling cranes in and stuff, it needs to be wide enough to accommodate for that vehicle to come in without smashing and
Yeah.
damaging everything else.
They need to.
So it's going to have to be
responsible.
wider than 8 foot, definitely.
Yeah. Yeah, and my suggestion would be that they build the driveway approach after do the restoration. Otherwise, they put in a new thing and then tear it up.
Yes, I agree with that.
So if they tear it up going in, they're gonna have to fix it to current city standards. Yeah. Yeah. Ultimately, if it's damaged, if there's one in place and it's damaged, they'll have to do it. If they can't make the corner and they drive through and roll over the culvert, they'll have to fix it. You know, any of those will have to be repaired based upon the driveway approach standards that you've identified.
And our inspectors will be all over this.
Yeah.
Okay, good.
They have to pull a separate permit just
Yeah.
for the driveway approach construction.
Okay.
And because it's an active one, they'd have to do it in 2 pours because they'd have to maintain access for the folks. And that's, like I said, assuming if there's one in place that already meets standards and it's not damaged, that one can stay.
Okay.
So I guess I'll make the amendment
I'm
that,
going to defer to you two because you guys are more technical on this than I am. So
you want to make the amendment or you want me to go ahead and make it?
You can go ahead and make it.
Make an amendment to item number 7 that the telecommunication company or their contractors will put in a new entrance to the driveway to meet current city standards. And that they will also put the driveway itself back to the current condition just immediately prior to starting their work.
Pre-construction condition.
Pre-construction
okay.
condition.
I thought,
Yeah.
I thought you were saying they would restore it right before they started work.
Oh, no.
Okay.
construction condition.
That I can understand. Okay.
Pre-construction, okay. Do I have a
Second.
second?
Second.
Clerk, call roll.
Mayor Boley,
Yes.
Melissa,
Yes.
Dennis,
Yes.
Deb,
Yes.
and Billy,
Yes.
5-0.
Now we'll move back to item number 7 as amended. It's no more discussion. Clerk, would you call roll?
Billy,
Yes.
Yes.
Dennis,
Yes.
Mayor Boley,
Yes.
Melissa,
Yes.
5-0.
Item number 8. The applicant has certified the capacity of the tower to accommodate 2 additional providers and a letter of intent to lease space. So an additional 50 foot in height, maximum of 150 feet may be added to accommodate co-location. Any discussion? If not, clerk call roll.
Mayor Boley,
Yes.
Dennis,
Yes.
Deb,
Yes.
Melissa,
Yes.
and Billy,
Yes.
5-0.
Number 9, that in rendering this finding of fact, testimony at the public hearing on June 14, 2022 has been taken into consideration. Clerk, please call roll.
Billy,
Yes.
Deb,
Yes.
Dennis,
Yes.
Mayor Boley,
Yes.
Melissa,
Yes.
5-0.
Thank
Now-
you. To clarify, because of what happened on the last scenario, instead of this going on next week's meeting, we're going to bump it to August 2nd so we can make sure that everything's cleared up and has went through legal to make sure he's had eyes on it before it gets to the Board of Aldermen. So this will be on the August 2nd Board of Aldermen agenda, not the July 19th.
I think we are ready to move on to the next agenda item, which is a public hearing.
We do have one person, and that's Mr. Eric Craig.
I will open the public hearing first,
Oh,
though,
okay,
correct?
sorry.
Going to open a public hearing on rezoning 551 South Commercial Eagle Ridge B1P parcel to B3. If any members of the public wish to speak for or against the item, please identify yourself, give your name and address for the record. You'll have 3 minutes to speak. And I'd first like to call on staff to present an overview of the proposal.
Thank you, Ms. Chairman. This matter is in the staff report identified as that blue area in the over aerial picture. It's the land when this originally was rezoned from agricultural in 2018. It was rezoned to B1P as a part of the overall plan, which was there was B1, R2, and R1 all on one tract of ground. So it was a B1P scenario. They wanted it business, but didn't know what they were going to use it for. So ultimately, they have now come forward and requested to be able to put in an office building there. And I expressed to them office building with the storage of of equipment for the, it's a development or it's a development company and a construction company, that it would not comply with the standard B1. It's for professional building offices, like doctors and lawyers and that kind of stuff offices. It specifically calls it out as professional offices. So they have to go to B3 and that's their request. The proposed findings of fact that are presented to you identify the issues as we saw them and give you an opportunity. This one procedurally, after the public hearing stuff will be similar. You'll vote on the proposed findings. If it passes, it passes. If we have another tie, then we'll go through each item of the specific proposed findings of fact. Does that make sense? There we go.
So
Okay.
just to clarify, I don't have to read each one of those unless we have a tie vote.
Right.
Okay.
Or we have some, yeah, I mean, ultimately, the vote is to approve the proposed findings. If the vote is either tied, which is a no, or it's a no, then we need to go through and
Okay.
then make the changes to those findings that
Okay.
you all, so.
Okay. At this point,
Mr. Craig?
Can everybody hear me? I need to do that again. My partner and I actually have a development company here in Smithville, and we approached Jack to put an office and also kind of a, necessarily want to call it a warehouse, but a place to store materials. We're trying to accumulate as many materials as we can and keep them on hand to get better, purchases on things like that. There will be some equipment, skid steers and things like that that'll be stored inside the property, trailers and various things, but just more construction related items. So I'm here to answer any questions that you guys may have or the public may have.
seeing no other comments, I will, oh,
Derek Basie. I live at 18206 Marcus Road. This thing will be right in my backyard. I've got 30-foot oak trees. It's going to tower above my trees. Property value is going to go down. It's already, the real estate association says it'll go down 7%. That's my concern. I hope you all take that in consideration when you vote. Sir, you're on Marcus? Yes, Marcus Road.
That's the tower.
that's the tower.
That's going to the Board of Aldermen on the August 2nd.
Okay, I'm sorry.
Yeah, you're fine.
This is off commercial kind of by the.
Go to high rise.
Seeing no other public, I will close the hearing. We'll move on to item number 6. Do I have a motion?
John?
John? Okay. Have any discussion on the findings of facts? If not, clerk, would you please call roll?
Mayor Boley,
Aye.
Dennis,
Yes.
Deb. Billy.
Yes.
Melissa,
Yes.
Alderman Chevalier,
Aye.
6-0.
This one will go on the Board of Aldermen with this recommendation on the 19th, so next week.
Item number 7, another public hearing. Clerk, do we have any comments?
If I may, I would like to clarify, state law requires and our ordinances require that we call a public hearing to discuss any textual changes to our code. This is a proposed discussion related to textual changes, so we noticed it up for a public hearing for that purpose. I would fully anticipate that if there is suggestions coming out of this commission tonight to draft something up that addresses some of these issues, that we will notice it up again for an additional public hearing on this specific language, if any language comes out, or if any changes are recommended, we'll see. So this was more of a technical requirement than anticipating people showing up. But I wanted to make sure that we opened it for the public to start the process of discussion.
So I guess I will open it. Seeing that there aren't any comments, we'll go ahead and close the hearing. And we'll go on to item number 8, discussion of outdoor storage regulations. Do I have a motion?
So moved.
Second. Okay, we're now open for discussion on regulations.
I provided you
Jack.
all with a staff report memorandum that addresses the issues that we're dealing with right now. So ultimately, in 2010, it looks, my research indicates it was sometime in the 27 meetings where the planning commission have revised the zoning code. We took out outdoor storage as it is defined in the code in most of the districts and required it to be in buildings. At that time, the planning commission wanted to tighten up outdoor storage. There were limited scenarios, very limited business going on. Ultimately, they made that recommendation. The old provision had outdoor storage is permitted if it is screened from the public view with 6 foot, 80%, 6 foot fence, 80% obscured. And ultimately, it has become a very burdensome scenario for our current businesses to maintain that, especially with the price of building a building to do those things. We've got probably 10 businesses in town that we're currently working on this matter with, associated with it. So before we start taking things to court with code violation scenarios, I wanted to give this commission the opportunity to discuss it and think of, do we want to continue this? Do we want to adjust it? And I will leave it up to you to start the discussion, asking questions or whatever, but just wanted to make sure that we were all on the same page as it relates to starting to enforce on some businesses. Generally, the one that I hear the most complaints about are people that go to Heritage or hit the Courtyard Park and have to see all the cars in the back. That would be outdoor storage of the car dealer or car repair place there. And all of that's clearly visible from the public way or to the public.
I thought we were supposed to have a fence up or something already, right?
That was in 2010. the commission in 2010 recommended that we take that provision out and make them in buildings. And that passed in 2013. Like I said, it took two and a half years, over 2 years, 2 years and 3
But-
months to get it
But
done.
either requirement, they're still not meeting it, right? If it was screening or building,
Yeah.
it's cars parked in the park that are there for business purposes are not meeting that
Yeah.
requirement.
So some of them have double violations from that standpoint. They don't even have the fence around it. Some of them have the fences, but the old code provisions took it out. For example, in the I-1 and I-2, that's the only place that the code would allow you to have outdoor storage properly screened.
And CPC is completely fenced, right? I mean, I saw them put up fence. It's like
Yeah.
8 foot tall, right?
But
And
the
yours is
other-
fenced too, right?
Yeah. So that's the, yeah. 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 I mean, there's the fence company around the corner here. They've got a fence all the way around.
Yeah, the
Yeah.
Ameren buildings has this old Ameren sign on it or whatever.
Yeah, that little yellow metal building there. Yeah. So that's the scenario. Do we want to require that stuff to be inside a building?
Side of building, but I think it needs to
Screen.
Screened. And the good thing is, we have all the language already drafted because the old code's it's quoted in here. So
be. But what was the reasoning in 2010 that they decided?
they wanted to tighten it up. Right.
But so also the new code for B4, they can't do chain link. It has to be,
Right. It has to be
Privacy fence.
decorative. It has
Yeah.
to be a decorative or wooden fence. It can't be chain link
Gotcha.
stuff. So prior to that, as the mayor was indicating, there were no front yard regulations in B4 because you can build your building on the property line. So when I got here, we had to adjust that because the code said you couldn't put it within 12 feet of the, right, well, that didn't.
They have zero build.
Yeah, when you have zero, you can put your building on the property line, but your fence has to be 12 feet inside your building. So it didn't make a lot of sense the way that was. We changed that provision, but now we're in a scenario where since 2017, we've exploded in business all around town. And now that we're having those issues arise and complaints are starting to come in, I felt my obligation was to bring it to you all and make sure we level the playing field because the code says everybody's got to have it inside.
So residential, you discussed trucks over 1 ton and RVs. What about boats? I'm assuming like U-Haul and moving trucks and pods but how long can a person keep a pod in their driveway?
Well, ultimately, if it's in the driveway and it's temporary, we don't have a regulation. Same thing with the boat. The only regulations we have for recreational vehicles or any of that kind of stuff for storage is that it be on gravel. It can't be on grass. You can't store on grass. That was a Board of Aldermen nuisance code change last November.
So that can be there indefinitely, except as neighborhoods themselves require.
Yeah, now,
Okay.
this would not impact one way or the other. If we allow it, HOAs could prohibit it. But if we prohibit it, HOAs cannot allow it. If that makes sense. It's a one-way street. So our standards are the minimum. So, yeah. And the other thing is you could also address that. The easy way to address it, if you don't want to change the residential stuff, if you don't want to change it, would be to put the language that used to be in all those provisions as it relates to the B1, B2, B3, B4 districts. It's already in the I-1 and I-2. And that's easy enough to do as well.
Is this going to the Board of Aldermen for discussion or is it going to stop here?
Well, ultimately, we'll see. If you guys make a recommendation to come out of here with something, it will go to the board. If the planning commission doesn't, then it won't. However, if we have an alderman that happened to be sitting here that wanted to discuss it at the board level, he could certainly do that in the future business.
That's what I was just getting at. I was
But how
curious,
many-
what I needed, if I should save most of my questions, I guess, until, unless it comes to the Alderman meeting, but it sounds like we need to have these discussions here.
This commission, since it's a zoning ordinance, really needs to set the term. What are the issues? And I think this would be the appropriate venue for you to say, I don't like this, but I like this.
Yeah, I mean, just talking about the boats, I mean, I don't think we need to really get many more regulation on boats. We're at Lake Town, so I mean, I kind of feel like we need to focus our targets on that, but yeah, I mean, I do think that we need to start enforcing some of the screening stuff and making sure that, everyone is, like you said, on the same playing field and is treated fairly.
Yeah, make sure you talk close.
Yeah.
So Brandon can hear you.
Yeah.
So, for my own clarification, this is not just a discussion for commercial purposes. This is also a discussion for residential as well.
No, and yes. This is a discussion on outdoor storage. So the question of outdoor storage is what we're discussing. Levels of it are I-1, B, the B districts, the residential, and you also have to throw in the ag. It's a slightly different if you have an AR district property, 2 to 3 acre parcel with a house. It seems to be, something you could equally treat with whatever you do in the residential. As it relates to the agricultural land, it's a, you can have 40 acre with
So on
cattle.
current standards right now, it has to be screened and 8 feet. It doesn't matter if it's a fence or it could be bushes or
No,
it doesn't.
currently in the I-1 and I-2, that is an option to screen it. Currently in the B1 through B4 districts and all the rest, it has to be inside a building. You can't store it outside.
Okay, what kind of complaints are you currently getting and from what sector are you getting them?
Outdoor storage, that looks like heck. Why do they get to do it, but they don't? Why did I have to put a fence up, but they don't? And the
Well, part of that
explanation
could
on
be is because like on,
the code changed.
yeah, that's what it was. When
Yeah.
I moved in, it was required and then evidently it got changed that it didn't.
Yeah.
So some of them have chain link fences and other ones have screen.
Some of them have, well, no, it's not really the chain link. Chain link fence will not meet the standard of
Right.
obscuring.
And it never did, correct?
Never did.
Right.
Never did.
You can put up for example, I'll go south, Shamrock Way and Commercial, where that intersection is. You've got Shoreline. They've got a chain link fence. This was before I even got here 15 years ago. They had the chain link fence, but it didn't obscure the site. So they put the slats in.
Right.
That's what I was gonna say.
Yeah, so that met the standard of obscuring from view. So you didn't have to look at all that.
But there are storage units that don't have, they just have chain link.
I'm sure there are,
Multiple.
yes, yes. Yep.
So I'd say, I mean, I guess, are you asking if we should also open it up to a chain link option? I mean, is that kind of what we're looking at here?
I
as
think
well?
what he's asking is right now, the current requirement is they have to have indoor storage.
Indoor storage. So now we're just trying
Chain
to,
link screening is not even an option anymore.
so if we want to add screening, we just need to define what those parameters look
Or
like.
go back to screening.
Yeah, I think we should go back to screening. And
Well-
then we want to make sure that, but now by doing that, how dicey is that going to get for the existing people that just have like outside boat storage or, and they just have a simple fence up? a chain link
169
fence?
storage is a good example. It's just chain link. You can see
Yeah,
everything in there. It's a nice tall fence, but it doesn't meet, they're not inside and they're not screened.
well, actually, Well, the other ones, that's all inside, so that wouldn't matter.
Yeah, it's all inside.
I think that's only.
But ultimately, I think ultimately the
says that, don't we?
scenario is if you look at in the staff report document, the second paragraph, in our code currently, outdoor storage is defined as the keeping of goods, equipment, property, et cetera, business related or otherwise, not completely enclosed in a building. That's outdoor storage. So everything that's outdoor goes there. And then we have a separate provision that defines on how that screening and what that is. And I don't remember. A solid or semi-solid fence or wall or trees or shrubs at least 6 feet, but not more than 8 feet high, except for trees and shrubs, and having a density of not less than 80% per square foot. Those provisions are in the code. They were never deleted because they still have to apply to the I-1 and I-2 districts. The question is, do you want to change that screening requirement? And two, who should it apply to? The business districts and the industrial districts?
I think,
all
I think it
districts?
should apply to business and industrial, but I don't know if you want to apply that to a residential. If somebody has a
No.
trailer parked at their house, do you want to make them build a fence around it?
No,
I mean, I don't
That's
think
been consistent.
I mean, I just think that'd be, yeah.
I'm also wondering, if, it's more critical, maybe say downtown, right? Where, we spent millions of dollars on a streetscape and we want it to look beautiful. We don't want it to look, really bad, but, maybe the 169 storage, since it's not really out in our face all the time, we may not need to worry
Can we
about
do
that
it
as
by
much.
district? Can we divide things by district?
We currently do. I-1 and I-2 is the only one that has it. So yes. Yes,
Oh.
everything's done by district.
Is,
So, yeah.
is 169 storage B4, is it still, that's B3 over there?
Yeah, it's B3.
Okay.
Well, yeah. And that, I mean, here's the counter to that scenario. If you do it in just B4 and not B1, 2, or 3, the visual appearance of the city is currently based on 169. So if that's the concern, then
Would self-storage fall into the category of business materials? Because it's mostly people's personal property in there, right?
well, right. And that's ultimately, yeah, goods, equipment, property, business or otherwise, not completely enclosed in the building is out.
But they would
So-
be,
I think you could probably consider it equipment,
gotcha.
probably under that definition.
Okay.
doesn't belong to the business
Or otherwise.
or
yeah.
otherwise.
Yeah.
So that would, if we change that, would they then have to improve their chain link, or would they be, they're already screened, or what's the,
That's ultimately where we're at.
gotcha.
Yeah.
Which I don't know if that's I don't know if it's a
And Major,
bad.
yeah, Major has a fence around theirs, right? Privacy.
Well,
Yeah.
some areas fence, most of it's the back of a building.
Yeah, same, yeah.
Yeah,
Two
same
buildings
thing.
and.
Because they're in the B4 0 lot line.
Yeah,
They can
yeah.
build right on the property
Yeah.
line. So that's how most of theirs, they've got lean-tos that back up most of the way around.
Because he built a new one too.
Yeah, he replaced the one that was problematic.
Against us.
Yeah, it was up against Billy's
Yeah.
place.
One of the complaints that I've heard over and over about storage is that coming down, mentioned 169 being our main drag. That's the entrance coming into Smithville. People are saying, I've heard people say it just looks atrocious, and here we got one more storage unit out there and it looks terrible. And I think at one time we talked about how to clean up and beautify the entrance into Smithville off the highway with signage or plantings or something. That was a few years ago. We talked about that. I can kind of see both sides. So, if you're out there on the highway and you've got storage and you've got RV, people want to park their RVs outside because they don't want to pay for inside storage, then you'd want those shielded. obscured from public view coming in, so it looks attractive, with landscaping and trees and things like that. So I could see, have shielded outdoor storage for things like that, but
But if we're.
to John's point, we just spent millions of dollars to make our city look really nice, and I would hate for something to come in and just really yuck it up again. So it's kind of a quandary here as to,
I think somebody's gonna be disappointed.
Well, yeah, absolutely.
Somebody's gonna be
No matter what happens today or in the future, we make a change or we don't, some people are going to be upset.
yeah,
So the question is, I don't think we need to look at it from the perspective of, will someone be upset? The question is, what's best for the community?
yes.
So B1 through B3. So B1 is, you said was business offices, right?
Yes.
And
yeah.
then B2 is,
A little higher, it's slightly different area. It's the stuff where you can have, for example, B2 at the intersection of Old Jefferson and 180th, that
Uh-huh.
corner, that's currently B2, I believe.
okay.
So
So
you could
then
have that kind of stuff.
B3 would be like major.
No,
me-
Major's in the B4 district. This
No,
is
no,
the
he's talking about Major
downtown.
Mall.
Oh,
Yeah.
yeah.
He's talking about Major Mall.
Yeah.
B3 is basically any business use along the highway. It's the highest business use intensity that we have. B4 is a niche area that is a little less intense than B3. And B4 is the only district that allows residential, the only business district.
So just like what we did with Eric up here, we just made that. So this would apply to him. He'd have to have fencing up.
Mhm.
Or storage.
Yeah, they'd have to
Indoor-
have indoor
yeah.
storage.
Indoor
Yeah.
storage or fencing.
According to the new code, they would have to have.
The
indoor
current
storage.
code, no outdoor storage.
So not to be funny, but I guess car lots fall into a whole other category because
Well, because
all
it's.
their equipment's outside on display.
Yeah, but that's
mean-
defined in here as merchandise for sale.
Yeah.
So if we have some equipment sitting outside, we put a sign on it, it's good to leave there.
All those RVs are for sale.
Just asking.
I'm willing to sell it there.
Yeah. One thing that, thinking about what Billy said, when he put his business in, he put in screening because that was the code, right? If we have people that are not following it, I think we need to enforce it either way, what the code, what it comes down to. It needs to be enforced.
Right. Which is the scenario we're in.
Yeah.
So,
Are we in process?
So
of enforcing
inside
this?
or
yeah, we've
screen.
got several of them.
Inside or screened.
Yeah.
That's really
One or
what
the
Jack's asking us. Do we want to make a
Do we want to
change?
keep it inside a building or do you want to allow people to have 80%?
I think you
Public
should
way.
have a screening. But the only thing is, if you don't set some really strict standards on that, then you'll have
Be
people
ugly.
parking their dump truck right next to a 6-foot
Yeah,
fence.
because it's not, 6-foot fence and
gonna
you gotta
be-
screen it.
Yeah.
Yeah.
So I mean, you really got to set some standards or something, because you can't just,
Unintended consequences.
yeah.
And some of it's just going to be, here's the deal, we can craft it as we got a lawyer in the room. We can get it as tight as you want it. And if somebody wants to mess with us, they can read through it and find, well, this is a loophole. I have people do it all the time. It's like, okay, that is an issue. I see where you're at. Here's the code.
I would like to protect the new aesthetics of the city, period. Because I think that is the highest and best good for the city. We need to look good. And we need to keep looking good. That makes us an attractive place to be. So if we do change to have some shielded or obscured, that, like you say, we need to make it tight.
And that aspect of it, I mean, 80% obscuring is easy enough to measure. We can measure that.
Yeah, a foot.
I see it.
I mean, it's just.
Yeah.
it's pretty straightforward
Well,
on
you would
that.
think we have folks that misunderstand 50% obscured fences, maximum. You know, it's like you'd think that if it's 50% open, that it would be one picket, equal gap and another picket. But some people think it means no, one picket, half of a picket width and another picket. And that means that it 50% open. It's, so we always have that. Ultimately, my office's staff has been, my staff has been down the path of, ultimately, we've interpreted it this way for this long. We're going to continue that. If you disagree with it, there is a venue for you to bring that up.
Isn't
It's-
there authority having jurisdiction? Isn't that the last person that says what's going on?
Well, ultimately, it's the judge, because we'll issue you a ticket and you get, that's where you get to argue the law. You know, you get to argue the law there.
Well, what's the problem with making it 90%?
Well, if you keep going to, I think 80 is good, because if you go more than that, I mean, all of a sudden, it'd be difficult to do. I mean,
Well,
it'd
the
just be-
problem, you can put a wood fence up and it would, but the problem would ultimately be one of structure of the, if you put up a vinyl fence that's, those vinyl panels, if they don't have any opening in them, it's a
they're
wind sail.
below it, I don't-
Yeah, it's a
yeah.
wind sail.
So has to approve the construction of the screening, don't they? So
It's
it's,
be, yeah.
It should be approving it through what the rule is, not how they
Right.
feel about it. So I
Right.
mean, we gotta make sure we get the
Yeah.
right rule set forth.
Right.
So in that 80% scenario, and like I said, somebody puts a dump truck that's taller than the fence, it's not.
There's not a lot we can do about that from the standpoint, we don't want the fences to be too tall, then you've
Yeah.
got the ugly look of a fence.
right.
Yeah, it looks like
Um,
we're, yeah.
Right. Yeah, looks like you're going through a war zone or whatever, high crime area.
So,
Yeah.
so if we did the screening, right, and then especially, say, I don't, however we do it, especially for the downtown, I mean, is this going to take care of most of the complaints that we have? And if someone decides to put a dump truck, could that possibly be a different change of use from what
Well-
they're supposed to be using their facility for to begin with?
Doesn't-
And they would have to come back to get change of plans at some point?
Well, if it's in the business districts, if they're parking a dump truck, it doesn't have to be a dump truck. It could be a food truck.
Mhm.
Food trucks can be tall like that too. So, we can call it a dump truck and then but ultimately the likelihood that somebody's got a restaurant that's gonna put a dump truck in.
Well, it'd be hard to obscure 80% a cherry picker.
Right.
Or big,
But if
big
you look at the
service
current
areas.
version of how it's defined, it's 6 feet tall, at least 6 feet tall, not more than 8. So between 6 and 8 feet tall and 80% obscuring, or you can do it with trees and the like. For example,
Combinations thereof.
on 169, where you have, it used to be Z's, now it's, right there by Hildebrand.
Dave's Auto Body.
Dave's Auto Body. The entire south side of that building and all of the storage area behind it is completely covered with those massive, massive evergreen trees. They're probably 25 feet tall and they're grown together. So you can't see through it at all. No, but they also have a security fence, but that obscuring,
but that's
is,
just chain link back to that.
yeah, but
So-
they don't have to have more. They wouldn't have to have more
No.
because it's obscured from the public way with this vegetative screening that's thick through there.
You'd think most businesses with assets would want to secure it.
somehow.
Yeah.
What do you think the backfire is by this, by reapplying or setting this screening back to code? I mean, what do you think is going to come back?
Well, to be quite
problems?
frank, if we go to the way it used to be, I think it will give us the opportunity on 2 fronts. One is if there are complaints now, why are you making me do this now? It is, well, it used to be you'd have to build a building to put it in. They've moved it back to the way it used to be in 2013, so 10 years ago. And here's, I mean, it makes it easier to go back to the old rule.
So I think if we focus on the downtown district, that would be key. I don't think putting a obscured fence around 169 storage is going to make it look any better or any, might make it look worse, you know? with-
Because all the RVs are tar,
Yeah, yeah.
goes back to
so-
the dump truck incident.
Yeah.
Yeah.
Well, that's part of the other issue with this is, you know, when you have a grade scenario, you know, they, on the south end of that up there, the weight station stuff, you know, that fence, 6 foot, even if it was 12-foot fence, it'd still be 10 foot below the road.
Right.
So you can see right over the top of it.
Yeah.
So,
Well,
Yeah.
same thing down here on the south side of town.
yeah, yeah.
I mean, 169 so much higher than all the area there. That's going to be same situation.
I think keeping B4 as it is, I'm fine with it staying indoor. Honestly. Here's the thing, if we change it, who says they're gonna comply with that either?
Well, ultimately, that would be a judge.
Yeah.
The question is it reasonable to require it inside a building? Would you be fine with a site obscuring fence to get us there? You know,
So
And-
what's all downtown? It's mostly B3,
B4.
right?
no, this entire area is B4 until you get across the river.
Mhm.
And then there's some B3 on the west side of Bridge.
Yeah.
All that's B3 through there.
Okay, how about this scenario? Keep it the way it is, and if somebody comes along and requests a variance,
Then we're doing it on a case by case basis.
Yeah, I don't, yeah.
And you'll have people saying, well, he didn't have to do it. Why do I have to do it now?
okay.
Let me just add a little bit. When you talk about variance, it's a great question. But on this type of scenario, you're actually talking use variance as opposed to non-use variance, which is a whole different kind of an animal. So there are different standards and so forth. I think all of us who deal with use variances at times are a little concerned about how that gets applied. Ultimately, it's going to be the BZA that would ask for that. But there's some authority at some time, some jurisdictions, you don't have use variances as such. But I think in Missouri, they're pretty much recognized at this point, but it's not part of the land, it's how the land's being used. That's what I mean by a use variance.
Right.
So what I'm hearing Jack say is, and I assume this is a recommendation for you to, you're talking about lessening the standards.
Restoring them to where they were.
The real battle comes out when you tighten them up, which the city's already done. And we're having now some of the repercussions for having done that earlier. But if somebody wants to argue grandfather or something like that, that's something
So-
that may ultimately end up in litigation and we get figured out.
So Jack, is there any business that you know of that had to build a building because of this? Okay,
That's my point. We're
Yeah.
about to the point where we're going to start making them.
okay.
When we weren't having complaints, it wasn't an issue. When we started having complaints, I cannot, in good conscience, only enforce this law against the one guy that's getting hammered with complaints. It's not appropriate for me to say he's the only one. I have to apply it equally.
I'm okay with this. Going back to the screening.
Storing it to the,
Yeah.
here's my suggestion.
Draft it.
I'll draft one based on the recommendation that I have in my memo. And then that's what will be put out for specifics for the public to be able to comment on. And we will have another hearing at the next meeting.
But are you looking at doing just what,
My proposal would be do it across all businesses.
Protect downtown.
Yeah. And downtown is obviously the driver behind it because it's changed down here. 10 years ago, it's a whole different, this was the Wild West looking
I think you
place.
need to also limit how much storage versus your building. You know what I mean? There's gotta be something in there because you don't want somebody to put up a little shack and then do 150 feet of fence.
Well, to a certain extent, we already have that with the fence guy across the street from you.
Yeah, because that's a bigger, a little building with a big area. And Jack, and it's not just the last 10 years. I sent this to somebody the other day. In 1843, Humphrey and Nancy Smith decided to move to Iowa. Smithville became a lively town in those days filled with taverns and hellraisers. It's not new.
Yeah. Yeah.
Not much has changed.
I'll get it drafted. You guys will have the public comment that comes at that meeting based upon an actual proposed draft. And then if you want to amend it, tweak it, it's the same as any of the other ones. I propose we take out B1, 2, 3, or whatever. That's the best way to do it.
Okay.
If I draft it with everything in it, it's easier to pull it out than it is to try and put it back in. Does that make sense?
Yes.
I will have something drafted and ready for the,
August meeting.
Okay.
Is your phone
oh, it's
vibrating?
her phone. Okay. Sound like a dog
It's her
barking.
phone.
So we'll
It's
move on.
vibrating. Is what it's doing.
And can I have somebody move to an adjournment to executive?
Here,
session?
here.
Mayor.
Motion to adjourn executive session pursuant to section 610.021 subsection 1 RSMO. You got the easy part.
Okay, all in favor, say aye.
Roll call. Roll call.
Oh, okay. Billy?
Aye.
Mayor?
Aye.
Deb?
Aye.
Melissa?
Aye.
John Chevalier? And Dennis,
Aye.
6-0.
John, can we just lock the door and turn off the mics? Instead of going back to the office here.
Will we be turning to open or will we be adjourning from executive?
Returning from executive.
It's right here.
There we go.
Turn off the Zoom. We can still keep the mics on if we need.